This is a press conference to address Ghanaians on the desperate act that the main opposition party, NDC, is involved in to shield Atufose, an accused person standing trial in our courts, from accountability. It is not in dispute that the justice delivery system is arguably the last bastion of a burgeoning constitutional democracy. And if it is constantly being bastardized by people who ought, in the very least, be responsible and know better, it leaves very much to be desired. We owe it to ourselves and posterity to rescue our dear country from this dark canker by those who have made it their stock in trade to spew vitriol and unapologetically take shots at a system they have little or no faith in at all. The NDC have since last week set in motion a malicious scheme fueled by lies, falsehoods, misrepresentations, blackmail, and needless pollution of the mass media, with the sole intention of obstructing the course of justice and scandalizing the criminal proceedings in the High Court, all in the bid to shield Atufose MP, minority leader in Parliament, and former Deputy Minister of Finance, and his associates from taking responsibility for authorizing some payments which resulted in a whopping sum of 3.27 million euros lost by the state. Monies that belong to us all as Ghanaians. Richard Japa. Out of these many people, the Attorney General convinced that the willful act of Kesela Atufose had resulted in a financial loss of 2,370,000 euros to the state, charged him before the High Court, together with Sylvester Animana, the former Chief Director of the Ministry of Health, and Richard Japa, a businessman, for causing financial loss, abetment to causing financial loss, and supplying public property. The court ruled, among others, that the Attorney General had led sufficient evidence to establish a case against Atufose and therefore ordered him to open his defense. Why would any credible person do such a thing? Indeed, if the Attorney General had any intention of having him skew the evidence in favor of Atufose, it would not just be just for the Attorney General to continue the prosecution of Atufose. But that is what the NDC wants us to believe. Investigations commenced as far back as 2017, making it imperative to ask at this stage, why is Atufose, the only government official, being prosecuted from all other former ministers from whom statements were taken? Your guess should equally be good as mine. Clearly, the prosecution is based on the various documentation available from the participating agencies in the transaction, and this is evidenced by the court's ruling upholding that the case has been made by the Attorney General that warrants an answer from the defense. It is also worth noting that the prosecution of Kesela Atufose commenced even before he became minority leader, making it worthless and nonsensical, the suggestion that he is being prosecuted because he is a minority leader in Parliament. This logic can only come from the NDC. At the time of the invitation, was unaware that the third accused person was going to be present, and therefore his subsequent appearance in the House of the Justice was surprising. It is pertinent to note that prior to this meeting, the Attorney General had closed his case, and the court had thrown out the application of Atufose for a submission of no case as being without merit. The third accused had also, by 4 different letters by his lawyers, requested and made proposals to the Attorney General for a plea bargain, which will see Big C third accused principal paid 2 million euros in exchange for the cessation of prosecution. This has been roundly rejected by the Attorney General. In fact, third accused, through his lawyers in the letter dated 16th May 2023, had indicated unequivocally that they were requesting a plea bargain, and following the rejection, I requested the AG for terms which the Attorney General will consider acceptable. The Supreme Court judge, Justice Emmanuel Yonikolendi, therefore sought to inquire whether there was room for a plea bargain, and the AG highlighted that he was not opposed, provided it was made in proper form, and assured third accused that he had nothing personally against any of the accused persons. The Attorney General further requested that since the charges principally focus on the public officials through whose actions the laws of association, which are JAPA, should show fidelity to the transaction records which were already in evidence. Finally, there is also a record that first accused himself, Keselatu Forcing, had, in the company of a senior parliamentarian, visited the AG in his house to plead with him to end the prosecution. The NDC, in their press conference today, have conveniently failed, refused or neglected to respond to this fact, which was also contained in the response of the Ministry of Justice following the proceedings of Thursday. Why will Atuforse go to the Attorney General to beg for a discontinuance of his prosecution, and the same person will, through another medium, say that the Attorney General is persecuting him? You can make the inference yourself. You are the best judges. Ladies and gentlemen, if the Attorney General desired to cajole the third accused as suggested, then the best avenue will have been following the third accused person's request for the AG to propose terms acceptable to him, and the several WhatsApp messages sent to the AG pleading with him. Clearly, the third accused person is a hired mercenary contracted to exploit his relationship with the Supreme Court judge, knowing the AG's inability to disrespect the said justice when invited after failing to secure a meeting with the AG. All this is against the backdrop that since the Attorney General was appointed into office, he has been arguably one of the most successful, both in and out of court. As remarkably noted by the President at the last State of the Nation's address, he has successfully saved the state over 10 trillion Ghanaian cedis, and his verve in protecting public resources is shown by his commitment to the prosecution of public officials whose acts have resulted in huge financial loss to the state. This is beside the other several infrastructure and logistical improvements to the Office of the Attorney General and Ministry of Justice, including the almost completed law house. Ladies and gentlemen, once again, it is the firm belief of the NDC and Atuforse. If it is the firm belief of the NDC and Atuforse that no loss had occasioned the state from its conduct, then they should just remain faithful to our judicial system and seize these malicious orchestrations targeted at bastardizing our judicial system and to prevent him from standing trial to its final conclusion. They should just keep quiet and let the proceedings in court continue. We are very clear in our minds that the cause for the resignation of the Attorney General is misplaced, unwarranted, and this will not put any spokes in the prosecution of Keselatu Forcing and his associates. Ladies and gentlemen, the call for the resignation of the Attorney General coming from the NDC is very, very rich. The NDC calling on the Attorney General to resign from office. That is rich Ghanaians. The AG will not resign. He will continue to remain witty, resolute, and focused in the delivery of his work, as he does always. The wheels of justice, we say, grind slowly, but eventually it will grind to a halt.